everybody. Welcome to today's conversation at the POSHpod, where we're talking about what the POSH Act means at the workplace and some of the concerns, questions, challenges, and even best practices that POSH practitioners have brought to the table. We've talked about the Act itself, constituting the IC, looking at the structure around anonymity in the Act. And Bishen, we've also kind of touched on why the Act is so specifically protective of women, right?
You go back and watch those episodes.
Today, I want to pick your brains on kind of like a corollary to that conversation, right? Something that is true in our culture and something that has been generationally transmitted, right, for many, many years is, and I briefly talked about it earlier also, the social stigma around sexual harassment. To the extent where I know as a parent, I have definitely spoken to my daughter about this, that when a woman is in any way uncomfortable in a situation where there is a sexual connotation, it could be somebody whistling at her on the streets, right? The advice very, very often is put your head down, pretend you didn't hear it, and walk away from the situation. Don't confront the issue, right? And then along comes the POSH Act, which specifically says, hey, woman with a complaint, you need to go and approach your IC. You need to identify yourself. You need to share information with the IC, very specific. And we know that sexual harassment more often than not occurs privately and without witnesses. The very nature of the situation.
Yeah.
So when you have a complainant who comes to the IC and says, and normally we refer to this as a he said, she said situation, right? So the complainant has brought a complaint to the IC. The respondent says, nope, it didn't happen. How does the IC take the first steps in a situation like that?
Yeah, big problem, Laxmi. I'm sure as a member on the IC multiple times, you've dealt with this hands-on multiple times.
Yeah.
But I think the short answer for everyone to remember is that the standard of proof to be implemented in a sexual harassment investigation situation is very different from the standard of proof that we imagine in a criminal investigation. And that standard of proof in a criminal investigation for murder, theft, etc. is beyond reasonable doubt. The court has to be satisfied beyond reasonable doubt that this individual is guilty of the crime, right? And we assume that sexual harassment is a crime and therefore the similar standards must apply. Quick aside, sexual harassment is a crime, right? Section 354A of the IPC also has sexual harassment as a crime. And what constitutes sexual harassment there is very similar to what constitutes sexual harassment under the POSH Act, right? Except that there isn't the last line which says any other unwelcome act. So the criminal law is a little bit more tight on what sexual harassment is. And if we were in court discussing whether certain action is sexual harassment or not, pursuant to a criminal complaint, then we would be following the standard of beyond reasonable doubt.
Sure.
But when we are looking at whether there is sexual harassment or not in a POSH situation, which is a complaint raised by an employee before before an IC, it's a very different standard we follow. And the standard we follow here is preponderance of probabilities, right? Preponderance of probabilities or balance of convenience are a couple of the phrases that are used, which effectively means that the IC only has to come to a decision on, is it more likely that sexual harassment happened or that it didn't happen? And when we say more likely, it is in the mind of the IC, the collective mind of the IC. Is it more than a 50% chance, essentially, that sexual harassment has happened or that it didn't happen? You don't have to reach the beyond reasonable doubt threshold. So that's the one big thing to keep in mind. I'll pause here. Laxmi, if you want to step in on examples or your experiences as a member on the IC on dealing with these situations.
Yes. So a couple of different things, right? I mean, one is definitely in terms of, okay, the complainant in her complaint has raised certain or described certain specific situations, right? Such thing happened while we were wherever, here or there. For example, this person asked me to stay back after my shift, and we stepped into a meeting room, and the situation occurred inside the meeting room where there was nobody, right? The other flip, and this is something that, because I don't have a legal background, I don't have this kind of training, right? And we've also seen the law does not say that you have to have only legally trained people on the IC. So for many of us in the IC, that's also a part of the struggle, right? You talked about balance of probabilities, and the law says, what's the evidence? Now the complainant says, this situation happened, as I said, back inside the meeting room. The door is closed. There's nobody there. And I'm telling you, it did happen. And I was traumatized by this. Respondent says, nope, it didn't. Or respondent could also say, well, it wasn't meant in that way, right? So then the IC says, we need the evidence. And complainant...
What do we do?
Yeah.
Right.
And you tell the complainant, please tell me, how can we from the IC's perspective, it's not about trust and faith and belief, right? It is, at the end of the day, a legal responsibility that the IC has, and we've got to take evidence into consideration, but there's no evidence.
So, okay, let's spend, I suppose, most of this episode, the entirety of this episode, discussing what those examples are, because that's what it comes down to, right? I can sit here and say preponderance of probabilities, balance of convenience, but if you cannot implement that based on the evidence that you have, there's little value in knowing what the standard of proof is, right? So, one thing to remember, again, different from a criminal kind of situation where you need direct evidence. In a criminal case, you need direct evidence, right? Of the witness having seen, heard, experienced something. In a POSH situation, you don't need direct evidence. You can deal with circumstantial evidence. And what is circumstantial evidence? Let's say that I was sitting in a room with the victim, and I have seen embarrassment on her face, or I have seen that she is upset, right? That's my perception of the situation. And there may be someone else who shares that perception. Now, before a court, that's not direct evidence. That's not adequate evidence to convict. But in this situation, you can, because you have a lower standard to achieve, you don't have to achieve beyond reasonable doubt, right? You only have to achieve balance of convenience. So this kind of evidence, you can take into consideration, which may be seen with the other evidence that you have, which we'll discuss examples of, could be helpful, right? Or the allegation by the woman is that so-and-so person harassed me when I was in the washroom, right? Nobody was there in the washroom, but I was standing outside the washroom when I saw her leave in a haste and looking distraught, right? Now, that evidence which I provide to the IC could be useful to the IC to possibly see the truth in the complaint, because it's unlikely that at the point in time when it happened, she was faking her sorrow and running out of the washroom, right? So those kind of pieces of evidence do help an IC, and the circumstantial evidence could be adequate to come to the conclusion that there was sexual harassment happening in this case, or there wasn't, right? So that can ultimately be quite helpful. Let's discuss a couple of more examples.
Actually, I do want to share something with you, and it's so interesting what you brought up, right? And linking it back to what we talked about, the handshake business. So this is a complaint that was brought to an IC that I was a part of. And the complaint, the woman complained that, look, our manager has this rule that when our shift starts and as we come into work, he's always there at the office before our shift starts, right? Each one of us, all of us, both the men and the women who work in the team, all of us have to go up to him, shake his hand and say good morning and, make the usual morning pleasantries. Now, for me, when, and this is the complainant speaking, right? So she says that when the manager shakes her hand, he holds on to her hand a little longer, and B, he makes an inappropriate touching, this thing, right? So she came and said, people can't see it because obviously, when you're shaking hands, you can't this thing. And the assumption is, why is only she so sensitive? I spoke to somebody else on my team who used to be on my team, and she's transferred to a different team. And she said she faced the same problem. But again, could not speak up about it because nobody knows. So how does an IC handle, because this is literally a he said, she said, because he's saying, I shake everybody's hand, not just hers.
So there's no one correct answer, honestly, right? But I think the example I gave before of someone seeing her reaction to it or someone seeing her experience to it could be helpful. Or in this case, after the handshake happened, right after, most likely she's gone and had a conversation with somebody about it.
Yes.
And said, this happened to me, right? So generally, courts and in ICs, which essentially have the powers of a civil court as well, tend to believe that immediate reaction post the happening of the event. And that kind of reaction must be given adequate weight. So right after the event has happened, if you know that she has gone and spoken to someone in confidence and said that, he held my hand a certain way, it was inappropriate, it was a lingering handshake, it was a touch was inappropriate, whatever, that has to be given weight by the IC, right? So when I said, let's talk about examples, it's a great example of examples of in this kind of situation, what would be evidence? Maybe this is evidence. You said that she knew somebody else who had experienced something similar. So if she says that to the IC should be able to say, let's call that person on as a witness. Let's hear that person as well. So there's no reason to disbelieve the woman here because it's not an isolated incident. There is some kind of pattern. So if you can establish some kind of pattern, even if nobody's actually seen that very handshake happen, right? There could be evidence enough to find guilty. So these are a couple of evidences that could have been used in this example.
So you're saying if there is a question mark, if the IC has a question mark and feels that perhaps the situation did in fact occur, that the IC can then reasonably, when they're talking to themselves, and going back to the wonderful 3-2, right? That they can actually find, and formally find that the likelihood of such a situation or such a complaint being valid is greater than the unlikelihood.
Correct. And like in this situation itself, now it cannot be that she is in isolation, right? This is happening in the workplace. She's going to be sitting at her workstation. She's going to be in the proximity of other employees, right? So even assessment, like the first example I gave, the assessment of her facial expressions, her body language in the office, pursuant to an incident where she may have experienced some trauma, could be telling, right? So the IC's obligation is then to go out and try to find that evidence, right? To the people sitting around her, to see. Again, this is how it's different from a court case, because in a criminal setting, it's the obligation of the complainant to provide the evidence.
Yes.
Right? In this situation, it's also the obligation of the IC to go and find the evidence. It's a way in which it's different, right?
Yeah.
Because a judge doesn't go out and do that in a court setting. But here you are the judge, but you can also be the investigator. It is a POSH investigation, right? So you can go out and try and speak to the people around her. See if there's an assessment of facial expressions, body language, whatever it is, conversations that could help in that situation. All kind of examples that, come together to either prove guilt or the lack of it.
So you're saying almost like wearing an investigating officer's hat, right? Talking to people and finding out a little bit more contextual around this and trying to get to a place where the IC can reasonably take a call.
Yeah.
Yes, it happened, or no, it didn't happen. We're also seeing that again, going back to sexual harassment tending to happen in private or without these open witnesses. But we're also seeing young women who talk to their friends about it, not necessarily friends at the workplace, but also maybe friends outside the workplace, right? Somebody who and again. Going back to the whole social stigma, the context around the need to identify myself as a woman who has faced sexual harassment, I will look for people that I'm more comfortable talking to, and these need not necessarily be people within the organization. Is there any value to that conversation that an IC can use or will appreciate?
No, absolutely. I mean, the conversation that the victim has with the third person outside the office will have the same value as someone within the office. Just because it's sexual harassment at the workplace, it doesn't mean that the evidence must come from the workplace. Absolutely not. But I suppose the more time that passes between the event and the conversation, the less... I also don't want to say less believable it becomes, but I suppose the more believable it is, the more proximate the events are, right? Because there's not enough time to fake a reaction. There's not enough time to fake emotion. if the harassment has happened in the washroom, you've come out distraught, spoken to a person there, it's natural that will have more value. Not to say that the other evidence will not have value, just that on a weight of evidence, it's likely that the person who is more proximate will have more value.
Yeah, and that's kind of a little thing, because yes, the law does say that, you've got to make the complaint within 3 months-ish of this thing. There's some nuances to that. But then there's also, again, the cultural this thing of, something happened yesterday, you're complaining today. Oh my God, why are you being so sensitive? And, where's the hurry of raising the complaint? And then something happens earlier on and you wait, and then you think, oh, so what were you doing all of this time? What were you thinking of? There is that challenge that women face. So how about, and again, I'm looking in today's world where I think all of us are so much more conscious around well-being and mental health. What if this woman says, I spoke to a counselor about it. I spoke to a therapist about it. We do know that there is, health in the healthcare world, there is that patient privilege, right?
Yeah.
How can an IC or can an IC use that information to help guide them towards a conclusion?
No, most definitely can, but you will know that any therapist or doctor will not break that privilege.
No.
And therefore, when you go to a therapist or doctor for this kind of evidence, if you are able to get the consent of the victim, the complainant, before you do that and get them to waive privilege, right? Because after all, the doctor or therapist is only protecting their privilege. There is no other privilege that he's protecting. So if you're able to get them to waive that privilege, you can definitely take that evidence on board, and that will be quite substantial in terms of finding guilt or the lack of guilt. But I want to add, what the conversation with the therapist is just another example where you may find similar evidence from experience is in the diary of the individual, right? Very often, if they have not had a conversation with a friend or a confidant, maybe they haven't gone to a therapist or a doctor, but there is still evidence in the diary that they maintained, right? The event happened 2 months ago, 3 months ago, like you're saying, but the diary from 3 months ago has a page on the incident that happened, right? Which adds to the believability of the accusations, the allegations. So there are, even in the absence of any evidence, there could still be evidence. And all these examples we're talking about is for the benefit really of IC members to look for these kind of evidences.
There's also this other this thing of from an IC's perspective, and again, like I said, we're all humans. So although we try to be sitting in the IC wearing a hat of impartiality and fairness and respect towards all, which is really true, but there's also this kind of gut feel, right? I mean, I kind of instinctively believe a particular situation occurred or didn't occur. How does an IC overcome that, or maybe manage that to ensure, once again, not ensure, but to get to a place where there is a consensus decision that's possible?
It's a good question, Laxmi, but I think the answer is that the IC just have to overcome that tendency to lean a certain way. I mean, your gut instinct for any investigator is important, and you must follow your gut, but you must follow your gut to chase the evidence. You mustn't follow your gut to conclude.
That's
right?
a good point. Yeah.
So all of these examples that we are thinking about now and discussing are what the IC, if they have a gut feeling leaning a certain way, must go and hunt down.
Yeah.
And if you hunt and don't find, then I suppose there is a reason to conclude, regardless of what your gut tells you at the end, there's a reason to conclude in the negative, saying the harassment didn't happen possibly.
Okay.
Right? Another example is what I just want to keep giving as many examples as I can is in the absence of people. Now, if the type of harassment takes some skill, so to say, in that it requires you to hack into a system, it requires you to send messages which are through your email, which you click and whatever, that possibly needs a certain amount of studying for the individual. And if you are in a workplace situation and we're discussing harassment at the workplace, there's a good chance that they are using office laptops or office phones to search for ways to hack, to access other people's phones, laptops, etc. So if you're able to go into their browsing history, and as an employer, if it's your of official property, you have the right to do that. So IC can access it. You may have evidence over there. Their search history may give you evidence about what it was. So those are little kind of things that could be helpful.
Yeah. So let's say, and from an IC's perspective, right? They've tried, they've looked for this thing, they've asked both sides, both the complainant and the respondent, do you have any witnesses, do you have any information, do you have anything to offer? And there is nothing. So then if we follow the structure of, look, I as the IC cannot find enough information about this, so therefore I will in my report say that this harassment did not occur. Does that automatically mean that I am penalizing the complainant? I mean, like being for the respondent, is can that be seen as IC being against the complainant or recommending action against the complainant?
Okay, yeah. So the Act very clearly says that if the IC finds a person not guilty, it doesn't mean that the complaint was false or frivolous. Now, the Act has provisions for what to do when there is a false or frivolous complaint, and the woman could be punished for it in the same way as how a man could be punished for harassment, right? The punishment is almost the same. But that's a very high threshold to meet. Simply an allegation being proved as not true does not make the complaint false or frivolous, and that's very, very clear from the wording of the law itself. And I think aggrieved women should feel confident that any finding of not guilty doesn't automatically make them guilty. And ICs should be able to also make the conclusion of not guilty for lack of evidence, right? You don't have to because your report will be on record forever. You don't have to give the accused a clean chit if you don't think there is a clean chit there. You've found him not guilty due to lack of evidence. You can state that it's not guilty for the lack of evidence and not because you found evidence in his favor. So it's about the manner in which you write it, and that's perfectly fine. So yeah, I guess that's where the IC needs to finally land. There are multiple kinds of evidence that you can access, which we discussed. But if you've gone through all of your options and still don't have anything, then unfortunately you don't find guilt purely based on the word of the woman, right? Because you need to at least meet the threshold of preponderance of probabilities, balance of convenience, and merely the word doesn't achieve that. But the fact is, you have so many tools to use the word of the woman to find in her favor. And if you've not been able to do all of that, well, unfortunate in that case, I suppose, or maybe the person was genuinely not guilty, whatever.
So kind of, we've done this entire thing. When I say we, I'm talking about the IC. We've completed this. We've created this report, and the law also says that a copy of the report has to be given to both the complainant and the respondent. So, as the complainant, if she's not happy with it, she can go on appeal, right? I mean, she can say that I'm not happy with the way that my complaint was discharged or was investigated by the POSH, by the POSH committee, by the IC, and therefore she goes on appeal. So it's not speak now or forever hold your silence.
No, absolutely. Okay. So the law provides, I think it's a 90-day window from the time the decision is made, from the time the IC makes its recommendations to file an appeal. So there is definitely a period of time that the woman can go and appeal it. And I should just add here, not directly related, that many employers sometimes choose to have an internal appeal mechanism as well. So sometimes women have two chances to appeal, one before your internal appeal mechanism and one before the statutory appeal mechanism. So those two options are often available to aggrieved women as well. Aggrieved women as well as the respondent, I suppose, if he feels that he's been wrongly adjudged as guilty.
Lots and lots to talk about, Bishen, and I'm definitely going to take you up on some of the points that you mentioned this time when we catch up in the future. And for all of you out there listening to us, thank you for your time, patience, and support. We're excited about having this conversation. We hope it's useful to you, and do like, subscribe, and come back to us with your comments, your questions, your suggestions, or even just, if you disagree with us, we'd love to hear from you. Thank you.